Welcome to the Tejswi IP Show. In this podcast, we dive into the world of intellectual property like patents, copyright, trademark, geographical indication, design. Also analyze the recent event in IP world. Today, we're particularly excited, really keen to share some incredible stories, surprising developments, and crucial updates from across the globe. We'll have a special focus on India's, burgeoning IP landscape. Whether you're a startup founder, an innovator, or just curious about how creativity and invention are protected, we think we have some really valuable insights for you.
Exactly. The world of IP is, well, it's incredibly dynamic, constantly reshaping itself. We'll be connecting the dots between legislative changes, landmark court decisions, and groundbreaking innovations. The idea is to illustrate not just what is happening, but really why these developments are so critical for safeguarding your ideas and assets.
Right. And India's IP landscape truly stands out, doesn't it? It feels like a vibrant epicenter of innovation and policy right now. So let's start our exploration right here at home, uncovering how recent developments are shaping the future of ideas in the nation. Starting with patents.
Sound good?
We've got some intriguing news with Clean Core Thorium Energy, CCTE they're called. They're actively seeking Indian approvals for their patented nuclear fuel. And this builds on a U.S. export license they already have. It's particularly interesting, I think. Cutting-edge U.S. nuclear fuel tech looking to establish its innovations right here in India.
And this international interest, it arrives at a really pivotal moment, doesn't it? Our government is actively engaged in modernizing patent law. That's a process that, well, it inevitably involves navigating global trade demands, especially with the ongoing negotiations with the U.S. And this brings us to a fundamental challenge. How do we effectively balance these global pressures with our own national interests, particularly in vital sectors like, say, agriculture and genetic resources, ensuring our rich biodiversity remains protected? That's key.
That is key. And speaking of protecting domestic industries, we recently saw something of a strategic win, right? With the India-UK Free Trade Agreement. The agreement was signed without introducing stricter patent extensions. That feels like a significant relief for our manufacturers and a real bolster for indigenous innovation.
Precisely. And if you look at the broader perspective, this really underscores India's evolving capacity. We're moving beyond being just an IP consumer to increasingly leading as a global IP creator.
Yeah.
Especially in these future-defining technologies.
Like AI.
Exactly like AI. We've actually ranked 5th globally in GenAI patents, according to WIPO. Now, this isn't just a statistic. It signals, I think, a profound shift. It's redefining India's economic potential in high-growth sectors. You see this translating locally, too. States like Uttar Pradesh are strategically leveraging their local intellectual property, especially designs and patents, as a cornerstone of their ambitious $1 trillion economy goals.
It's really compelling to see how that national leadership translates into state-level IP strategy. It's not just big corporations either. Grassroots innovation is flourishing. Take VIT Chennai, for example, signing MIUs for patent commercialization. That fosters crucial industry-academia links. And get this, students in Kerala are apparently nearing a patent for their innovative dog-repelling stick.
Huh. That's brilliant.
That story perfectly illustrates how institutional support can meet everyday ingenuity, doesn't it?
It really does. It's those kinds of diverse stories that truly showcase the breadth of innovation happening all across India. So from patented inventions, let's maybe pivot now to creative works. Copyright.
Okay, copyright.
It's facing its own set of, well, pretty intense challenges, particularly with the rapid evolution of artificial intelligence.
Exactly. And a crucial question facing us, I suppose, is can our existing laws truly keep pace? I mean, with the rapid advancements of AI, an 8-member government expert panel has been formed specifically to assess if the Copyright Act of 1957 can adequately address these complexities, the ones introduced by AI-driven infringement.
Yeah, and the intricacies AI introduces for copyright are just immense. For instance, what even constitutes authorship when an AI generates content?
Right.
And where do we draw the line for infringement when AI models are trained on these vast data sets, many of which contain copyrighted works? These are the really nuanced questions the panel will undoubtedly be grappling with.
Definitely. On a maybe more traditional front against online piracy, the Delhi High Court has sent a pretty clear message. They ordered a nationwide block of Sci-Hub, the academic piracy site. It's a strong move, ensuring creators and researchers see their work protected.
A decisive action indeed. Now, shall we turn our attention to trademarks?
Let's do it.
This area is experiencing, well, an unprecedented surge in activity.
It certainly is. I saw the numbers. An incredible surge in trademark applications, 5.4 lakh. That's 540,000 filings in 2024 alone, which places India third globally in applications. And it seems largely driven by a vibrant startup ecosystem and, interestingly, more non-traditional marks being registered.
Yeah.
It really showcases that entrepreneurial spirit blooming across the nation.
And a key aspect to consider here is how this surge reflects the explosion of new businesses and brands entering the market. With so many new players, developing strong trademark strategies becomes more critical than ever. It's a real competitive advantage in a crowded marketplace.
Absolutely. We even have a live example of how quickly these disputes can escalate. The Bombay High Court recently issued an interim injunction. It restrains Cognizant from using its logo in a dispute with Atyadi Technologies. It just shows how swiftly courts can intervene to protect established brand identities.
Precisely. And in response to this growing complexity, it's actually great to see technological solutions emerging. Entermark, for instance, have launched an AI-powered trademark watch tool. It's specifically designed to help corporates, attorneys, and startups manage their expanding trademark portfolios. It's a perfect example, really, of technology being used to help manage the very challenges that technology itself often creates.
That makes sense. Shifting focus again, let's talk geographical indications, or GIs. There was an interesting ruling from the Delhi High Court concerning PISCO. Chile and Peru will now need to use Chilean Pisco or Peruvian Pisco to clearly differentiate their products. So no more mistaken identities for your favorite spirit.
Yeah. From a broader perspective, this ruling is quite significant for GI diplomacy and for establishing cooperative standards internationally. It acknowledges the shared heritage between nations while ensuring absolute clarity for consumers. It really shows a growing understanding, I think, of how to manage shared cultural assets on a global stage, moving towards more cooperation and mutual recognition.
That's a great point. And on a similar note, India has successfully secured international protection for the iconic Darjeeling Toy Train logos.
Fantastic news.
Protecting a piece of our national heritage on the global stage, that's definitely something to celebrate.
Absolutely. And beyond specific cases, India is also seeing broader policy shifts in IP. For example, our Commerce Ministry has this ambitious plan to scrap, I believe, 1,000 IP provisions within 45 days.
Wow. 1,000, that's a lot.
It is. It signals a clear drive to streamline and modernize our IP regulations. The aim is greater efficiency and, ease of doing business across the country. And this push for modernization aligns with global efforts, too, like the recent WIPO treaty.
Right, that WIPO treaty. That felt like a huge step forward for safeguarding indigenous wisdom and biodiversity, widely celebrated as a crucial win for the Global South, offering enhanced protection for genetic resources and traditional knowledge.
Definitely a landmark agreement.
So, having explored India's dynamic IP scene, let's maybe broaden our lens now. What major intellectual property movements are shaping discussions and pushing policies on the global stage?
Okay, globally. Well, in patents, we have a fantastic example of green tech driving innovation. Unilin has secured a U.S. patent for their circular recycling tech, known as the OSIRIS process.
OSIRIS, okay.
This innovation isn't just a patent. It's a solution that transforms fiberboard waste into reusable materials. It showcases how IP is really vital for advancing sustainable solutions worldwide.
That's great to hear. And courts are also busy, right? Continually refining how they view design patents.
That's right. They're adapting, particularly after the Federal Circuit's ruling post-LKQ. Design patent obviousness is now being aligned more closely with the standards for utility patents. Essentially, it raises the bar for what makes a design truly novel.
A higher bar, okay.
Furthermore, in biotech, NeoGenomics recently won a significant genetic testing patent case against Natera. This reinforces the critical role patents play in protecting, huge investments in the rapidly evolving biotech sector. It strengthens enforcement in a field that's absolutely vital for future health solutions.
Globally, though, that critical question looms over copyright and AI, doesn't it? What's fair game for AI learning, and what's just piracy? The U.S. Senate recently took this up, holding a hearing on AI copyright piracy. Seems there's a bipartisan consensus forming to crack down on AI training that uses pirated works.
And this really raises that important question about transparency and accountability in the whole AI development process. In direct response, the TRAIN Act has been introduced in the U.S.
The TRAIN Act?
Yes, it would require AI firms to disclose the copyrighted training data they use. It pushes for clear attribution and hopefully, more ethical AI development practices.
Interesting. Europe, meanwhile, is taking a very strong stance on data transparency, too, kind of setting a precedent. The EU has published its AI Act data transparency template. Mandatory summaries of scraped domains are due by August 2027.
Yeah, August 2027. It clearly puts the onus on AI developers to be upfront about their data sources. No hiding anymore. Now, moving on to trademarks and trade secrets globally. We're seeing some truly high-stakes corporate drama play out.
Indeed. That XAI story. Elon Musk's AI venture suing an engineer for IP theft, alleging they shared secrets with OpenAI.
Right.
That's a fierce battle over trade secrets, really showcasing the intense competition in the tech world.
And this kind of case just highlights the critical nature of trade secrets in these competitive industries. And frankly, the lengths companies will go to protect them. They often form the core of a company's competitive advantage, their market differentiation.
It's not just tech giants either. Even universities are fiercely protecting their brand identity, making sure their image isn't diluted. Ohio State University, for instance, is challenging the Buckeye Tears trademark from a restaurant.
Buckeye Tears.
It shows how even seemingly lighthearted uses can become serious IP battles.
Absolutely. And we also see IP being used as a tool of national policy, influencing global economics. The U.S. has tightened chip IP rules for Korean firms operating in China, directly affecting major players like Samsung and SK Hynix. This isn't just about IP enforcement. It's really about geopolitical and economic strategy. It shows how intellectual property can become a powerful instrument of national policy.
Definitely seeing that more and more. Okay, let's maybe turn our attention now to some recent court decisions that are actively shaping the IP landscape, offering some valuable precedents.
Sure. In U.S. patent law, we had a pretty significant ruling in Mondes Technology, Ltd v. LG Electronics. On August 29, 2025, the U.S. Court of Appeals for the Federal Circuit actually reversed a $45 million jury award against LG.
$45 million reversed. Wow.
Yeah, ultimately finding Mondes' patents invalid. This ruling represents a notable shift in precedent on claim validity and infringement. It significantly reshapes litigation risks for tech giants by setting, well, a demonstrably higher bar for patent validity.
That's a substantial reversal. So when we talk about this higher bar for patent validity, what's like one practical step innovators can take today to ensure their claims are truly rock solid from the get-go?
That's an excellent question. I'd say innovators should prioritize clear, precise claim drafting, leave no ambiguity, and conduct thorough prior art searches before filing. The days of just filing broad, vague claims are quickly fading.
Okay, clarity and thoroughness. Got it.
And closer to home, in India's trademark law, the Delhi High Court ruled in Infosys Ltd v. Southern Infosys Ltd on August 28, 2025. The court barred Southern Infosys from using its old name after the injunction was issued. This clarifies how courts enforce trademark protection beyond the initial registration. It strengthens remedies and compliance in active brand disputes. It's a clear message. Ongoing vigilance is key for brand owners.
Right. This really drives home the message that trademark protection isn't just a one-time filing, is it? It demands continuous monitoring and enforcement from businesses.
Exactly.
Okay, let's zoom out a bit. What are the bigger picture themes, the overarching trends shaping the IP world right now?
Well, a major trend is definitely the global consensus forming on data transparency concerning AI and copyright. We see this in the U.S. with the Train Act and in the EU's AI Act. Transparency seems to be becoming non-negotiable for AI developers.
Yeah, that seems clear. And it's also really inspiring to see how sustainability is driving green tech patents. From Unilin's circular recycling tech to new energy solutions, IP is clearly going green. It's playing a crucial role in environmental innovation, bringing solutions to market faster.
Absolutely. And we're also witnessing the rise of what you might call GI diplomacy. Cases like PISCO demonstrate how shared GI rights are setting cooperative standards internationally. It fosters cultural recognition and consumer clarity in a, let's face it, complex global market.
Right. Okay, before we wrap up, we always like to leave you, our listeners, with some actionable insights and maybe something to ponder. For our IP tip of the week, we're talking about IP-backed financing for scaling without dilution. Sounds interesting.
It is, and it's underutilized here. Few businesses realize that their patents, trademarks, and copyrights can actually be used as collateral. You can secure loans from banks or NBFCs, non-banking financial companies here in India, under the RBI's evolving guidelines. While this is pretty common in the US and EU, Indian startups and SMEs are really just beginning to leverage this powerful option.
Okay, so what does this all mean for you listening? Well, Filing an IP valuation report with a certified valuer could potentially unlock significant working capital. And the key part, without giving up equity. That could be a true game changer for IP-rich companies looking to grow and scale their operations.
Definitely worth exploring. Now, for our IP term of the week, let's explore evergreening via divisional application.
Evergreening, okay.
Yeah. Beyond just the pharmaceutical sector, where it's maybe more known, companies are increasingly using divisional patent applications, not just for legitimate splits of subject matter, but sometimes tactically to evergreen their patents.
How does that work?
By keeping overlapping claim sets alive for longer. Now, India's patent office has begun scrutinizing this more closely, especially after cases like Boehringer v. Controller, but it remains a, shall we say, sophisticated strategy for extending market exclusivity and effectively slowing down generic entry for critical innovations.
Wow, that's a super clever, if maybe complex, way to maintain market advantage through IP. Definitely demands a deep understanding of patent strategy.
It does.
And for our fun corner this week, did you know courts once seriously debated whether a fragrance could actually be copyrighted?
Yes, it's a fascinating bit of IP history. In the Netherlands, there was a case, Gekova v. Lancôme, back in 2006, and it briefly recognized copyright in perfumes, treating the fragrance itself as a literary artistic work.
No way. So what happened?
Well, the EU court later rejected this idea. They held that smells are simply too subjective. They lack the stable, identifiable form required for copyright protection.
Ah, okay. So today, perfumes are primarily protected through other means.
Exactly. Through trade secrets like the formula and trademarks, think of the unique bottle design, the branding, rather than copyright for the smell itself.
It's a quirky detour in IP history, isn't it? Really shows how far courts once stretched to try and protect unique forms of creativity.
Indeed.
So as we look ahead, there's plenty more to keep an eye on. India's AI copyright panel report is expected soon. That'll be interesting. And EU AI Act compliance for training data source summaries is due by August 2027. So still some time, but it's coming. As you can see, intellectual property is such a dynamic force, constantly evolving and influencing, well, everything from global trade to the products you use every single day. It truly is the currency of innovation, and understanding it is key, we believe, to navigating our rapidly changing world. Thanks for listening. Stay tuned for more upcoming episodes. And for reliable and expert intellectual property legal services, contact Tejswi VIP today. Our team of experienced attorneys is dedicated to helping individuals and businesses safeguard their intellectual property rights in the digital age.